Going into court to argue your own case means lawyering yourself up a little, which, without law school under your belt, might seem like a difficult thing. However, it doesn't mean you can't be a competent litigant. Something you may need to do as an independent litigant in a case is handle depositions. A deposition is when a witness's testimony is recorded under oath by a court reporter before the trial. It is one of the most common tools for discovery, along with requests for production, requests for admission, and interrogatories. Depositions usually take place away from the courtroom, generally either in a law office or the court reporter's office. A deposition tells you what the witness, also called the deponent, knows. It also preserves what they say for trial. Now, a deposition doesn't only involve testimony favorable for your side. It may also deal with testimony favoring your opponent. This is okay, because if a witness's testimony damages your case, you want to know about it beforehand, so you can prepare for it as much as possible. The last thing you want is to be surprised in court. When you take a deposition, you'll want to make sure your questioning is as thorough as possible. You may not get another chance to talk to this witness before trial, so be sure to prepare your questions before the deposition, and make sure you've outlined all the areas you want to cover. What information do I want from this witness? Do I need any events described by this witness? Will this witness help identify documents or other witnesses that might have evidence for my case? To begin your deposition, make sure the court reporter swears in the witness and that the witness states their full name. Once you get started, unless the witness needs to clarify what you are asking, the witness does not ask any questions during the deposition, only answers them. The witness or the witness's attorney may, however, object to the question, but generally, such objections are just for the record so that the judge can rule upon them at trial. Unless the question seeks privileged information, the witness must answer your question anyway. Take your time and make sure you get through all your questions. But don't be a slave to your list of questions. Listen to the answers and be ready to ask different questions depending on what the witness says. While you should be thorough, you can't harass the witness by asking a lot of questions that aren't related to your case. If you're just trying to harass the witness can terminate the deposition and ask the court to focus your questioning, and maybe even ask the court to punish you. Remember that the court reporter is recording every word for word, both questions and answers, and any discussions or remarks. So it's best to remain calm and professional throughout the deposition, no matter what happens. Sometimes, a witness's deposition can be videotaped. The advantage of this is that you can play the video for the jury. They can see the facial expressions and pauses, which help them decide whether to believe the witness. At the end of the deposition, if you got answers that you might want to use at a hearing or trial, you need to order and pay for a transcript from the court reporter. The court reporter will type up what was said into a booklet or electronic file. The witness has the right to read that transcript to make sure they didn't misunderstand a question and to confirm that the court reporter captured everything correctly. After confirming that everything is accurate, the witness signs the transcript. Depositions can be a fast way to get valuable information to win your case. You just need a little preparation, and maybe, sometimes, a little help from Legal U. You can do this.